Okay, we have a superstar. You know, we had, everybody remembers Rob. Oh, by the way, Rob Chang, who's the second speaker, property management company, RC Real Estate, everyone remember? He has a book. That is on the AOAUSA.com website. You can buy that book at AOAUSA.com. There's a shop, there's a place where it says there's free forms, but there's also, I think, order forms. So in the order forms, it should be there. That's what they told me. It should be there if you want to buy that book. And but we have another author today, and let's see. He wrote Estate Planning for Real Estate Investors, Maximizing Your Wealth and Preserving Your Legacy. So we talked a little bit about asset protection. What is interesting is that you have a master's in tax.
Tax law, yeah. In
tax law. So this is, you are very hard pressed to find anybody who has that kind of degree along with the estate planning, being an estate planning attorney. So his credentials are like a thermometer. There's lots of degrees on his resume there. And you know, he has a weekly radio show, and he used to do a weekly television program as well. So we're dealing with a celebrity here. Ali, it's wonderful to introduce you. Thank you so much for everything that you bring.
Thank you, Jeff. Thank you so much. I'm not sure if my mic is on.
Oh, let's make sure. Now you're on.
All right. Jeff, thank you so much. I really appreciate it. It's always very joyful for me to be here, part of AOA, and get a chance to talk to folks like yourself. I am from Los Angeles. My firm is in Los Angeles, but I was born in San Jose, so I'm very excited to actually be here. This is coming back home. So today, I'm glad we got Randy sort of talked about estate planning and trust and those sort of things, and I'm going to hopefully maybe explain certain other things and other plannings and different things that we could do. That's my goal today. I'll tell you a little bit about myself. Jeff did a fantastic job. We're a trust and estate planning state firm. We don't do anything else except trust and estate. And at first, I just went to law school, started practicing estate planning. And then I realized when you start doing advanced estate tax planning, when you start doing asset protection planning, you really need to know more about tax law, property tax law, and business law, and all that stuff. So then that's why I went back to school and ended up getting an advanced tax degree. I do host a weekly radio show. It's on 6:70 a.m. It is in Farsi. So if you don't speak Farsi, please stay in here. I'll try to speak English most of the time. But that's on every Friday at 9:30, and I get to talk about the same stuff that I'm talking to you about today. My goal here today is to hopefully teach something to you that you don't know. I'm not here to sell you anything. I do have a book. It's only $25. I'll tell you if you want to purchase it. I brought a few. But the goal is to really try to talk about stuff that I personally enjoy. My wife got tired of me talking to her about it, so she said, go to AOA, talk to other people. So I'm going to talk to you about estate planning, you know, the proper way of doing estate planning. And my agenda today is to talk to you about the difference between a revocable trust and an irrevocable trust. That's a question that comes up often. We're going to talk about how we could avoid probate, why we would want to avoid probate. We're going to talk about how a revocable living trust, which is very similar to a land trust, how they cannot provide any asset protection and they cannot do any estate tax planning. We're going to talk about how to do proper asset protection planning, and we're going to talk about estate tax planning, how we could avoid paying estate taxes if we have higher estate, and how to disinherit the IRS. Nobody wants to pay the IRS anything. All right. So revocable versus irrevocable. That's the question I get often at least once a week, if not more. And the problem is there's so many different information online. When you search, there's so many different things that comes up. And hopefully what I'll be able to do to you, what I will be able to do today is to explain this to you so you can hopefully get a little better understanding as how they are different. When we're talking about a revocable trust, who has a revocable trust? Quite a few people here already have a trust. The biggest difference when you're talking about a revocable trust versus an irrevocable trust, it really just focuses on the fact that who has the power to cancel the trust or revoke the trust. I can draft you 2 trusts that would be identical. Everything in there would be the same. The only thing that would be different is that who has the power to cancel the trust versus who doesn't have the power. That would be the only thing. So I could make you a revocable trust that would be identical to the irrevocable trust, with the only thing different is the person that created it does not have the power to cancel it. When you talk about a revocable living trust, this is like almost the foundation of estate planning. When you start doing estate planning, the first thing you need is a revocable living trust. Sometimes people ask, do I need a revocable trust or an irrevocable trust? That, to me, that's like asking a question from a builder, do I need a roof first or a foundation? I mean, you're always going to need a foundation first. So these revocable trusts are very similar to a foundation. When you're talking about a revocable trust, the creator of the revocable trust has the power to revoke it. So if you have a revocable trust, can I revoke your trust? No. Your trust is almost an irrevocable trust to me because I have no power to cancel it. When we talk about an irrevocable trust, all we're saying that the person that created the trust, he or she does not have the power to cancel it by himself or by herself. We do a lot of irrevocable trusts. We do a lot of asset protection trust. And I'll talk to you a little bit more about what type of trust we're going to need. We're going to need an irrevocable trust if we're doing asset protection trust because we don't want to have the power to revoke by ourselves. So the biggest difference between these two is the revocability of it and who has the power to revoke. And then keep in mind that all these revocable trusts, as I mentioned to you, the person that created the trust, they're the only one that have the power to cancel. And since we all, at someday, we're going to pass away, all these revocable trusts will automatically become irrevocable. So then, technically, all these trusts, at some point, they're all going to be irrevocable. Sometimes people get a little scared about irrevocable. They think it's, that's it. If they create a trust that says it's irrevocable, they could never change it. And the truth of the matter is that it's really not true. If the trust is drafted, more comprehensively, you could have it set up in such a way that there could be some changes made. Even California Probate Code, you see it up there, 15404A, it says a trust may be modified or terminated by written consent of settlor, that's the person that created the trust, and the beneficiary. So even if the trust doesn't say anything, you still could revoke an irrevocable trust without a court approval. So there are ways, so don't get scared of an irrevocable trust, because if we want to do proper estate tax planning, we're going to need an irrevocable trust. If we want to do proper asset protection planning, we're going to need an irrevocable trust. If a trust is irrevocable by itself, that still doesn't mean you're going to get asset protection. There are other steps, other requirements. But the first requirement, realistically, when we're talking about asset protection and estate tax planning, is irrevocability of it. Before I get too much into all the details that I have here, what I want to do is kind of explain some of the roles within the trust, just to make sure we're all sort of in the practical, somewhat same level. There are 3 or 4 different roles within a trust, different players within a trust, and I think this is a part that a lot of people get confused. We have the person that creates the trust. They call this person the grantor. However, sometimes they refer to him or her as the trustor, settlor, or trust maker. 4 different names, and that's why a lot of times people get a little confused. They see different names in different documents. If your trust says you're the settlor, doesn't matter. You're still the person who created the trust. No difference. What I'll do is I'll go through these things, explain what those terms mean, and then what I'll do is I'll go back up and say if it was a revocable trust, who would serve in those positions, versus if it was an irrevocable trust, who would serve in those positions. So again, we could try to figure out what's the difference between a revocable trust and an irrevocable trust. So the grantor, then we have the trustee. The trustee is really the manager of the trust. If you're creating, in a trust setting, they refer to him as trust. If you have a will, they refer to him as an executor, as a personal representative, administrator. But in a trust setting, they refer to him as a trustee. Then you have the beneficiaries. And then a lot of times people automatically assume when we're talking about beneficiaries, we're talking about their kids, their grandkids, but that's not really true. You can name different people as beneficiary, but more importantly, there's two types of beneficiary in every single trust. Doesn't matter what kind of trust. You have a current beneficiary, and then you have a future beneficiary. And then when we go through revocable and irrevocable, I'll sort of explain this further. And then we have a trust protector provision. This trust protector provision is really intended to provide more flexibility within the trust. Again, if we're doing asset protection, if we're doing estate tax planning, this trust protector helps us avoid going to court if we want to make some changes, if we want to cancel the trust, if we want to add ourselves as a beneficiary to the trust. Through a trust protector, we could do those things. All right, so let's go back. A revocable versus irrevocable trust. In a revocable trust, you're the person that is creating the trust, you're the grantor. Same thing in an irrevocable trust and any other trust. If I'm creating the trust, it doesn't matter what type of trust it is, I'm the grantor of the trust. The next role is the trustee of the trust. This is the person that manages the trust. So now if I'm making a revocable living trust, in most cases I could be the trustee of the trust. There's no issue. A lot of times if people are married, both spouses are the trustee of the trust. Something happens to first spouse, the surviving spouse is the trustee of the trust, and then we have successor trustees named. In an irrevocable trust setting, we don't want you to be the trustee of the trust. If we're doing this for asset protection, we don't want you to be the trustee of the trust. If we're doing it for estate tax planning, in most cases, we don't want you to be the trustee of the trust. So that's usually one of the differences you see in an irrevocable trust setting, again, for asset protection or estate tax planning. Beneficiaries of a trust. In a revocable trust, when we set this thing up, when you name your kids as the beneficiary, they are technically a future beneficiary. They're not the beneficiary of the trust right now. You are the beneficiary of the trust when you set up the trust. In an irrevocable trust, we don't want you to be the beneficiary either. And I say we don't want you to. The reason is that if you end up setting up a trust that you are the beneficiary, it could be even an irrevocable trust. For asset protection, you get no asset protection. So don't get fooled by the fact that a trust says irrevocable trust or a trust, or the name of these things don't matter so much. It's really the content of it, the structure of it that gives it the asset protection, gives it the estate tax planning that we want to do. So in an irrevocable trust that we're doing, in most cases we're naming our children as the beneficiary of the trust now. They're the current beneficiary and they're also the future beneficiary. So those are some of the differences that you'll see in these sort of trusts. Trust protector could be for both trusts, doesn't matter. All revocable trusts become irrevocable, we talked about it. The reality of it is the reason why we would use a revocable trust versus an irrevocable trust is just what we are intending to do. Revocable trust plans for incapacity. For a person passes away, avoiding probate, all those things we could do. We could do planning for a special need child that we may have, for a child that is under the age of 18. We could do all those things with revocable trust. Again, it's the foundation of estate planning. That's the first type of trust we're going to need. An irrevocable trust we could use for estate taxes. We could use it for asset protection, and I'll explain that further. All right, let's talk about probate and how we can avoid probate by having a trust. Before I tell you how you could avoid it, probate is a legal court proceeding that allows and provides a way for the person that passed away for his or her asset to pass to their kids. And usually this happens if the asset is named under one person only, solely under the person that passed away. And sometimes it depends on the type of asset. In most cases, real estate, LLC interest, membership interest, partnership interest, a stock in a small corporation or any corporation, those are a type of assets that are susceptible to probate if we haven't done the right planning. So how do we avoid probate? Is that we want to have a trust. That's a step one. A step two, we want to make sure we fund the trust. And that's the step that I see many times with apartment owner association members, that they sort of miss that. A lot of times they have asset under an LLC. They may have transferred their title to the property to their trust, but they don't have their LLCs transferred. Their LLC is still owned under their personal name. They may have written it in the back of their trust, but that doesn't mean a whole lot. You need assignment document. We need to have more comprehensive document that says these membership interests that I have in ABC LLC is now owned by my trust. It becomes really important because you could have the nicest looking trust, but if your assets are not within the trust, it's going to still require certain probate court proceeding and things like that. The other two steps are really the main reason a trust doesn't go to probate. One is the trust does not die or does not expire at the time the person that set up the trust passes away. And also we have a trustee who has legal power to conduct business on behalf of the trust after the person passed away. So, give you an example. Let's say you decide to transfer a real property that you currently have. You want to transfer it to one of your kids. You're selling it to them, you're gifting it to them, that part doesn't matter. The document that we're going to need, you're going to need some sort of a deed. In most cases, it's a quitclaim deed or a grant deed that transfers the property to them. And in transactions like this, if you're in a sale transaction in escrow as a seller, you sign the deed. If I'm buying your house, I don't have to sign anything. I don't have to do anything besides giving you money. You are the person signing the deed as the grantor, granting the property to me. And it could be to a child, it doesn't matter. But the reality of it is, in order for a property to transfer, transferring as a gift, transferring because I passed away, now it's an inheritance, doesn't matter. In order to transfer, we need some sort of instrument to make the transfer, and it has to be signed by me as the grantor. Now, I am not alive. I would most likely not have the power to sign. If I did, it would probably be scary. So the biggest thing that a probate court does, it selects somebody and gives that person the power to sign on behalf of the decedent's estate. So now if a person owns a property, passes away, and the property is supposed to go to the children, this person that is the executor, the personal representative, or administrator, again, 3 different names, all meaning, referring to the same person, that person would sign. So now when you have a trust, as we mentioned, we create the trust, the property gets transferred to the trust. It's not owned by me anymore, it's owned under my trust. I pass away, my trust's still alive, and then I have a trustee already named in the trust. The trustee doesn't need a court order to get its power. It already has power to conduct business on behalf of the trust. And that's how we get to avoid having to go through probate. And the reason you don't want to go to probate, particularly in California, is that the cost is very high. It takes a long time. Unfortunately, we do probate, not something I really like to do, but we do it because of the type of business and estate planning. There are people that come and see us that just haven't done the right estate planning or whatever the case might have been. Our average case is a year and a half for probate. So it takes a long time. It's private and it takes a long time. So that's why we would want to have a trust, a revocable living trust, to be able to avoid probate. Let's talk about why a revocable living trust is not good for asset protection. Right? I know the last session we talked about asset protection a lot. So for probate purposes, I just went through and explained to you how for probate purposes, the probate court says if you created a trust, you transfer your assets in there, for probate purposes, you don't own the assets. They're not a probatable assets. So now if the person passes away, there's no need to do any probate because technically he didn't own the assets, right? However, when we're talking about an asset protection case, and let's say the creditor got a judgment, and now they're trying to come after your assets, they're not going to just stop because you said I have my asset in a trust. That's not good enough. They're going to say, well, okay, I mean, if you have asset under your name, it's really easy. For example, if you have your home under your personal name, then all they got to do, they got to take a summary of the judgment, they call them abstract of judgment, and they record it in the county. They could record it on every single property that you own on that particular county or every other county they record it. So it's very easy for them to be able to record it. But now we're saying, I got it under a trust. No, that's not good enough. Because what the court says is that if you have it under a trust, we're going to kind of look into the trust and see what sort of powers you have within the trust. So if you created a trust, that you can revoke it. It's a revocable trust. A land trust, that's a revocable trust. So again, the court looks to see, what kind of powers do you have? I can revoke it. I can change all the beneficiaries. I could amend it. I am the beneficiary of the trust. I use everything that is inside the trust. I have every single power I had before I create the trust. IRS, the court says, you know, you have a trust like this. The assets that are in there may not be part of your probatable assets. They may not have to go to probate. But we're not in probate. You're alive, and now you got a creditor that has a judgment against you. The assets that are within a revocable trust will be included for for a creditor being able to attach it. So again, a revocable trust is not going to help us in estate asset protection. The land trust, it's a revocable trust. It's not going to help us for asset protection. What Randy was emphasizing is that what we want to do is we want to create some way to be able to give ourselves some privacy. And that is one of the first steps that we want to do in asset protection. Obviously, if they cannot find our asset easily, would make it more difficult for them to bring a lawsuit. They may not even go after us. So that's definitely step one. But I don't want you to stay at step one, because you know, if you actually have a lawsuit filed against you, unless you're willing to lie under penalty of perjury and go to jail, I'm not sure how you're going to, you know, they're going to say, do you have a trust? Yes, I have a land trust, or whatever, you know, a revocable trust. That is part of your estate. That is part of the asset they could attach. So now if we're doing a true asset protection planning, we need to have a step 2, a step 3. We need to really make sure we bolster this thing. That it's not so much that they can't find my asset. Asset protection planning, we're not intending to hide stuff. No. That's not asset protection. We may make it more difficult for people to find our asset, but we need to have more substance to it. And I'll discuss what we can do. But that's the reason a revocable trust won't work for asset protection trust, or a trust that you have that much power over. For estate tax planning, what the IRS says, they do the same thing. Estate taxes, they look to see how much is the value of your estate at the time you passed away. Again, if I have properties under my own personal name, it's easy to calculate. When I have property under a trust, same thing. IRS says, well, I'm not going to say this asset is not part of your estate because you have it under a trust. We're going to look to see what sort of powers you have within the trust. And again, a revocable trust, it has so much power in there that it's part of your estate. IRS says, you know what, I don't care that you have it in this trust, we're still going to calculate it. Sometimes it's a good thing, because if they could calculate it within our estate at the time we pass away, we get that step up in basis. If I don't have a large enough estate, I don't want to do a trust that the asset is not in my estate. So sometimes we do this purposely. We want to make sure that we set up a trust that the asset is included in our estate. All right. I briefly mentioned this, with asset protection or estate tax planning, irrevocability of the trust is step 1. It does not mean that just because you have an irrevocable trust that, again, you're going to get asset protection, you're going to get estate tax planning. I want you to really grasp that, because I see it often that people just, I have an LLC. LLC means nothing. It depends what the operating agreement of the LLC says. I see a lot of these sort of simple LLCs, they don't do any asset protection, because in the LLC it says all the income of the LLC shall and must be given to the member every year. We don't want that provision in an LLC, because if I'm sued, all my creditors got to do is just wait and they'll get the funds. So I want you to go beyond the fact that I got an LLC, I have a trust. We want to see it's written in there. All right, so let's talk about asset protection planning. I have a total of 40 minutes, so I'm going to sort of be a little bit more brief on this, but I won't go through all the details. But with asset protection, what I want you to keep in mind, there's really two big concepts with asset protection. One is we want to do something that you are not the owner of the asset anymore. You're not the beneficiary of the asset in the trust either. But we want you to be able to have indirect control over the asset. So that's really number one. If I can create a trust that you transfer your asset in there, and now if there is ever a lawsuit filed against you, you don't own the property. For example, if somebody sues me, are they going to be able to put a lien on your home? No, I don't own it. So with the irrevocable asset protection planning, what we're trying to get to a place that if there was ever a lawsuit filed against you, even if you told them that, they'll, in deposition, they'll ask, did you ever create a trust? Did you ever transfer a trust? So you're going to answer everything truthfully. You don't have to do anything that would be considered unethical. But the way the trust is structured is that you don't own it anymore. With asset protection planning, the timing of it becomes really important. When we do the planning becomes very important. Obviously, what we want to do is we want to do the planning before something bad has happened. That makes our asset protection much stronger versus us trying to do something after there's a lawsuit filed against us. But again, big picture, with irrevocable asset protection planning, what we're trying to do, we're trying to say we are not the owner of the asset anymore. The trust is. Right? And then sometimes I have people tell me, well, that's great, but you're saying with an irrevocable trust, I cannot be the trustee. You're saying I cannot be the beneficiary. I don't want to lose my stuff to a creditor, but it looks like I have no control over this thing. I have no benefit. And again, that is something within the trust that we could modify. I was talking to you guys about indirect control. So give you a couple examples. In these irrevocable trusts, I don't want you to be the trustee of the trust, but I can draft the trust in such a way that whoever you name as the trustee, your kids, spouse, friend, whoever it is, you have the power to remove the trustee for a cause or no cause. You can veto any decision or any action they do. You can change beneficiaries of the trust. You can borrow money against the trust. You could swap asset within the trust. So we could build in a lot of powers within the trust that gives you truly a lot of control. If, for example, I was the trustee of your trust, and I knew that if I did something without your okay, I'll get fired, what do you think? I'm going to do what you say, At least tacitly, we have an understanding that I'm going to do what you said or I'll get fired. So again, with these irrevocable trusts, we could build it in such a way that allows for much more flexibility within the trust. When we talk about LLCs, right? LLCs is another sort of aspect of these things. What we do with LLCs or partnership, family limited partnership, we're really changing the way you own the asset. So if you own an apartment building under your personal name, you actually own the apartment building. Somebody sues you, like we discussed, they could put a lien on the property and all the other stuff. You have it under a land trust, they may have a hard time finding it, but the truth of the matter is if they do find it, they could undo it and take it out. So again, we need to do more than step one, particularly if you have a larger estate. In an LLC partnership, they have the same remedies. I would not recommend having you put a property into a corporation. For tax reasons, being a tax attorney, you want to stay away from that. There's only one or two different cases that might make sense, but in most cases, what we want to do is hold our asset, our real estate, under an LLC or partnership. When you transfer the property into an LLC, you don't own the property anymore. Somebody sues you, they cannot put a lien on the property. Again, if somebody sued me, they couldn't put a lien on your house because I didn't own it. Same, almost relatively same concept. Somebody sues me, I don't own the property. I own the membership interest of this LLC. I own the partnership interest in this partnership. So they cannot come after they cannot go after the property. They cannot place a lien on the property. So what can they do? They have different rules. They have a charging order. They could get a charging order. What is a charging order? A charging order is an order that a creditor can get that says anytime the LLC makes a distribution out before I, the owner, the member, get the distribution, they could kind of come in the middle and take the distribution. So what it does, it automatically puts them on a payment plan without you negotiating for it. So if somebody, got $1 million charging order against my LLC interest, and I get a $100,000 distribution every year, now they're on a 10-year plan. And then again, if we drafting the LLC with asset protection in mind, we could have provision in there that says the LLC doesn't even have to make distributions to me. Obviously, if I'm in a lawsuit, I don't want any distributions. So now a creditor would have to, think again, do I want to spend all this money to get this charging order? And I may not get any money for a long time. I may be responsible for paying the taxes on some of the distributions. So again, with LLC, we're not saying you don't own it. With the irrevocable asset protection, we're saying you don't own it. That's probably better than the LLC, but the LLC is still pretty good. Sometimes some of the assets we cannot put into the LLC. Like your personal residence, in most cases, probably not the best idea to put inside of an LLC, because the first thing you do when you create an LLC to ask, what is the business? When you go to get an EIN, it says, what type of business are you going to run? Nothing, I'm going to live in there. That's not a business. So you technically couldn't put it inside an LLC. So that's why sometimes you have to pick different planning. But within an LLC, what we're doing, we're just making the asset less desirable for a creditor. Asset protection, there is no 100%. Somebody told you I could do 100% asset protection planning for you. They don't know what they're talking about, or they're not being truthful to you. Asset protection, what we try to do is we want to make it more difficult for a creditor to come forward. They may see the structure. I may have a good insurance policy in place. They're going to get that. They're much more willing to settle with me. It's going to give me something so I can leverage it to be able to negotiate with the creditor. That's the idea of asset protection. Again, I talked to you about operating agreement. Again, with these things, it's not that I have an LLC. That doesn't mean a whole lot. It's the other stuff that goes inside of it. This is a little flow chart of some of the stuff that we could do. Sometimes we do land trusts. Sometimes we do LLC. Sometimes we do Wyoming holding LLCs, attach them to revocable trusts, irrevocable trusts. I mean, we could do different plannings. But what I want you to mainly grasp here is that if we're doing comprehensive asset protection or estate tax planning, we need more parts into this plan. In most cases, one thing is not going to do us a whole lot. Let's talk about estate tax planning a little bit. And I have about 9 minutes, and I'll try to do the best I can. With estate tax planning, there's an exemption every year. This year went up to $13,610,000. However, this exemption sunsets in about a year and 10 months. And it goes back to what it used to be, which should be about $7 million in 2026. If somebody has a larger estate, and a lot of the clients that we're currently helping, we have a client, AOA member, over $50 million in asset. What we're doing is that the idea is that we want to do the advanced estate tax planning now to be able to use the exemption. I went a little too far. The $13,610,000. Because if they don't do the planning and now it's 2026, they're going to lose 6 or 7 million of it. And if they're married, you time that by 2. So estate tax planning becomes important if you have a larger estate. If your asset is below these exemption, then it may not be as important. The other thing in my next example is that we don't want to just look at what I have now. We want to look to see what is the likelihood of me being alive, how, in average, what my asset would grow every year. We want to try to calculate. The estate taxes are not due paying now unless you pass away today. But that's not going to happen because IRS says if you're 58 years old, in my example, you get to live at least 28 more years. And so if somebody has a $10 million estate, there might be no estate taxes now. But if it grows 5% in average, it doubles every 14 years. So 58 plus 14, 72. That's 20 million. 72 plus 14, 86. The same person that would have no estate taxes at age 86, now they have a $40 million estate. Even if the estate tax exemption doesn't change, you still have a taxable estate. So that's the main concept. This is a list of some of the trusts that can be used for estate tax planning. In the book that I have in the back, I published this book in November or December, September of last year. And I go through this thing. Chapter 3, Chapter 4 talks about asset protection, talks about estate tax planning, all the trusts that we could use and why we would use one trust versus the other. I initially had written it, and it was like 200 and some pages, and the publisher said, no, this is too long. Nobody's going to read this. So we had to, bring it down, and now it's only 75 pages. But the idea is that I want it to be an easy read, that my clients or people that are looking to do estate planning would actually read it. But it really has all these main point about why we would want to think about doing this type of planning and what's the benefit of it. One of the trusts that gets used a lot is this trust called a Slat. We estate planning attorneys use a lot of acronyms. This is Spousal Lifetime Access Trust. Because again, with estate tax planning, we're saying we're creating an irrevocable trust. Irrevocable trust, in order for it to work, we're saying you're not the manager, you're not the beneficiary. And so a lot of times clients say, well, I really like my kids, but I really like to keep my lifestyle. So if you're saying put all your asset in this trust and you don't own it, you're not the beneficiary, how am I supposed to live? So this trust, the Spousal Lifetime Access Trust, allows me, I'll use myself as an example. I got a 5-minute warning, 3-minute warning. Okay, so it allows me to put my spouse as a beneficiary, and I could create the trust, and I get to technically use the asset of the trust indirectly through my spouse. So this is a trust that gets used a lot in estate tax planning. The other one is this thing called upstream planning. Nobody likes to pay capital gains tax, and nobody likes to die. So, when the person passes away, you could get a step-up in basis. In California, you get 2 step-up in basis at the time the first spouse passes away and the second spouse. This particular trust, the reason it's called upstreaming, it's a trust that allows you to name one generation up. Again, as beneficiaries, we always think our kids, our grandkids, but the IRS does not have anything that says that's what you have to do. I can create a trust, name my wife as one of the beneficiaries, make it a SLAT, Spousal Lifetime Access Trust, and I could also name my father, my grandfather, one generation up, and then give them a general power of appointment. And at the time the older generation passes away, the asset in the trust gets a step up in basis without me dying. So I get a step up in basis without me dying, and I'll show you where this gets reflected on the tax return. As I mentioned, I'm a tax attorney. We filed a 706. This is a United States tax return, right? You see on number 14, it says, did the decedent ever possess, exercise, or release a general power of appointment? I told you we create a trust, give them a general power of appointment. So it says if they had it, we got to mark it here. Then they have a Schedule H. It says powers of appointment. So then I would write here the apartment building that I had in the trust, which I gave my, let's say, grandfather a general power of appointment. It says description of the property, and all the way at the end it says value at date of death. So now if this building is worth $10 million, I put $10 million, I got a new basis now. I have a $10 million basis that I could depreciate, I can sell without doing a 1031 exchange, without paying capital gains tax. I'll be here, my book, I don't have a whole lot, but I have enough. I have few that if you like to purchase, I'll have it for sale. And if there's any other questions, I'll be more than happy to answer. Thank you.
Really high-level guy, isn't he? I mean, just incredible.
Thank you. Thank you. I appreciate it. Thank you. Thank you so much. It's always a pleasure. Thank you, guys.
Yeah. So another round of applause for Ali Talai.